All right, we have a hard deadline, hard as in I've been told the only thing I'm responsible for doing is making sure that we finish at 5:25. So I'm just going to just get started right away since we're already running a couple minutes behind and hopefully won't hurt anybody's feeling. I'm David Skeel, as a number of you know, and probably some of you don't know, a law professor here at the moment. I was invited to introduce myself before I turn to our three panelists. So I thought this might be a great opportunity to tell you what a brilliant scholar I am, that I am a fine teacher, and one of the key institutional players who helped make this law school the remarkable place that it is. But unfortunately, a few of you know me and know that these things aren't quite true. So I'll introduce myself slightly differently. I am a corporate law and bankruptcy specialist here at the law school. I have been here for 8 wonderful years. I started out at Temple across town, 8.5 years. No, I've been here for 12 wonderful years, 12 and a half. Yeah, you didn't exist, or I didn't exist or something. I've been here for, I think it's 12 and a half exactly, after being at Temple across town for 8.5 years. And I certainly hope to spend many more years right here. For the last 3 or 4 years, I feel like I've spent most of my waking hours thinking about the financial crisis, thinking about the reforms, trying to write about the financial crisis and write about the reforms, trying to learn things that everybody else doesn't know about the crisis and the reforms. So this panel is going to be a huge treat for me. Because we have 3 panelists who know things about the crisis and the reforms and what's going on Wall Street, what's going on in Washington, that the rest of us don't know. So I have lots of questions to ask them. I might not get a chance to ask them, but I suspect you do as well. The way we'll work it is I'm going to relatively briefly, slightly more than relatively briefly, introduce each of the panelists in the order that they'll be talking. So I'll do all the introductions first, then each of them will speak for about 10 minutes, at absolute most 15 minutes, and then hopefully we'll have lots of time for conversation and questions and things of that sort. So starting with the first speaker will be Bob Hoyt, who is in the middle right here. Bob will talk generally about the kinds of tools that the government now has as a result of the Dodd-Frank Act, the new financial reforms, to deal with the problems exposed by the recent crisis. Bob graduated from the law school in 1989. He is a senior vice president of the PNC Financial Services Group, where he serves as the Chief Regulatory Affairs Officer, the Senior Deputy General Counsel, and the Director of Business Planning. He's responsible for a wide array of legal issues at PNC, and he leads PNC's relationship with the government, including its regulatory affairs and government affairs operations. This will all sound relevant to what we're talking about, even more relevant. Before joining PNC in 2009, Bob was General Counsel to the U.S. Department of the Treasury in some relatively significant years, from December 2006 to January 2009. A few things happened in those years. I wasn't going to say that. As General Counsel, Bob served as the Chief Legal Officer of the department and as a Senior Policy Advisor to the then Secretary Henry Paulson. Among other responsibilities, he directed the administration's legal strategy for managing significant events that year, which included Bear Stearns, Lehman Brothers, AIG, Fannie and Freddie, etc. Before that, Bob served at the White House as a special assistant and associate counsel to President George W. Bush. And even before that, he was a partner at Wilmer, Cutler, Pickering, Hale, and Dorr. Next up will be Heath Tarbert, who is sitting right next to me. He graduated from the law school in 2001, 8 years ago, I think, or something like that, and completed an SJD in 2002. He'll be talking about some of the effects of the Dodd-Frank Act on large financial institutions and other private actors. Heath currently leads the Financial Regulatory Reform Working Group at the law firm Weil, where he is also recognized for his transactional and regulatory expertise related to U.S. and foreign banks. Of particular relevance for this discussion, Heath recently served as special counsel to the U.S. Senate Banking Committee, where he was a lead expert and negotiator on the various legislative proposals that culminated in the Dodd-Frank Act.
So it's your fault.
I was a very bad negotiator.
So we're spreading the blame. It's not my fault. Nobody listened to me or listens. During the height of the crisis, Heath was associate counsel to the president, which meant acting as counsel to the National Economic Council, the Council of Economic Advisors, and as White House legal liaison to the Treasury Department, Federal Reserve, FDIC, and SEC. And during this time, I am told that Heath and Bob spent many late nights together talking about things other than their families and what they were going to be doing when they got out of Washington. Heath also immediately or shortly after graduating from the law school clerked for Justice Thomas on the Supreme Court. Our third panelist is Alan Beller, who will be talking about some of the corporate governance and consumer protection dimensions of the new financial reforms. Alan graduated from the law school in 1976, and he's currently on the law school's board of overseers. He is the former director of the Division of Corporation Finance at the Securities and Exchange Commission, where he served from January 2002 to February 2006. He also acted as senior counselor to the commission, a new position that was created specifically to take advantage of Alan's unique qualifications and ability to make meaningful contributions to all facets of the SEC's work. Following his departure from the SEC, Alan rejoined Cleary Gottlieb, where he had been a partner before he came to the SEC. He has worked at 3 of Cleary Gottlieb's worldwide offices, New York, Paris, and Tokyo, and his practice has focused on the entire spectrum of corporate securities and corporate governance issues, both domestic and international. So as you can see, if you didn't know already, and you probably did know already, we have an unbelievable panel, and so I will stop talking and let Bob start talking.
Thank you very much. It was not my fault, just for the record. I asked David to include this in the introduction. Everything was working fine when I left. Just fine. Whoa.
Yeah, I like this story.
I'm going to take care of Alan here. So the title of the presentation is Before and After. I'm going to try and handle some of the before part to set the stage for Dodd-Frank and some of the financial legal reform that we are still seeing playing out. You see up here we have the timeline, which has been put together noting some of the significant events starting back in 2007. To keep it short, I was going to sort of hit 2 aspects of the challenges that the government faced before the financial crisis. And the 2 aspects I would talk about, one are tools and the other is information. On the tool side, I remember in 2007, Secretary Paulson called me in and gave me what most lawyers, law students would consider to be a great assignment. He said, Bob, he says, we're in for a heck of a time here, I can tell. I want you to figure out what are all the tools I have at my disposal to, to influence things, fix things, change things. It turned out to be a trick assignment, probably something like what Professor Skeel would give us students for a test, because when we went and we looked, the toolkit was pretty light. As it turns out, we did have pretty much blanket authority to tell national banks and thrifts to do anything we wanted them to do. but it didn't extend to investment banks or other parts of Wall Street, which were pretty significant in terms of the impact. And it certainly didn't get to hedge funds, structured investment vehicles, all the other types of entities that certainly back in 2007 were at the forefront of the liquidity and other crises. It also turned out when we looked at the GSEs, Fannie Mae, Freddie Mac, et cetera, we didn't have a lot of tools there. We had the ability to limit their debt issuances, but that had never been used before, which was a problem, and it really was a little bit too late, since there was probably a couple of $1 trillion in debt floating out there already that most foreign countries and many people in the United States thought carried an implicit, if not explicit, U.S. government guarantee. And then it turned out, this was surprising to me, because I wasn't a banking lawyer going into the government, it turns out we had no money to spend. You would have thought the Treasury, we got the IRS, they collect the money, we have the FMS, they manage the money, but we have no money. We even have a room in the Treasury building called the cash room, but there's no money. Not even in the cash room I looked. The first place I looked. So we basically had no money. We had one exception. We had one fund of $50 billion called the Exchange Stabilization Fund, which you could use to stabilize the currency, and had there was a little bit of precedent for it being used for that before in the 1990s during the Clinton administration. But that was it. We looked in the rest of the government, and once again, the tools were very, very thin. The tools that ultimately ended up being used to manage some of the different events you see playing out in the slide to your left, it's a very few. You had the Exchange Stabilization Fund. That ultimately was used to create an insurance fund for money markets when money market funds, one money market fund broke the buck, meaning its value went to below $1. And that started a run on money market funds, and we used the $50 billion to create an insurance fund. It was a bit of a legal stretch to say how that related to the exchange rates, but we said, well, just, if you knew what would have happened if we hadn't done this, you'd understand. That was the story. And it carried the day, only about one day. The next authority was Section 13.3 of the Federal Reserve Act, not a Treasury authority, but authority basically owned by the Federal Reserve System. And that's an authority that enables them to lend really to anybody, not even just to member banks, but basically to anybody under almost any structure in exigent circumstances, so long as the loan was secured. And that was probably the single most widely used authority, and that was used to bridge the Bear Stearns transaction when J.P. Morgan bought most of Bear Stearns, but not quite all of it. It was used to finance AIG when it had its liquidity crisis. It is the authority that would have been used for Lehman Brothers had the other components been in place to permit a rescue of Lehman Brothers. Probably, actually not even probably, without question, the single most important legal authority that existed in the government through the crisis, and was used in a very smart way by the Federal Reserve throughout it. Also used to create different programs, not institution specific, but programs that could give liquidity to different classes of securities. Similarly, you have what's called the discount window, which is the Federal Reserve's regular lending authority to member banks, and that was used to accept different and unusual and less liquid forms of collateral than would typically be the case, and once again allowed banks and other financial institutions to get over their shorter-term liquidity crises. You had the systemic risk exception. This is an authority that the FDIC has. It's actually a more modern authority, or was a more modern authority at the time than others. And that allowed the FDIC to provide assistance to a bank without taking it into receivership in the event that the events or the bank would present a, quote, systemic risk to the economy. As I said one late night when people were debating whether we should use it, I said, if this isn't systemic risk, I don't know what is. And that authority ended up being used very broadly to create, both to facilitate specific transactions of banks that were on the verge of failure, like Wachovia, when it was initially sold to Citibank or Citigroup before that deal was undone, and then ultimately to create a very successful program whereby bank debt was guaranteed, allowing banks to issue debts with actually very little risk to the government, but with that government backstop, it again provided liquidity. And then finally, the ever popular TARP legislation, which gave us new tools. That's not one I could research in 2007, but one that was created in 2008, which initially the idea was to buy securities that were illiquid. It ultimately became, most importantly, a vehicle for capital infusions into banks. And I think that your chart, Heath, it says over 650 banks, I think, ended up with TARP funding. So that's where we ended up on the tools. On the information side, and this was quite interesting to learn, it turns out we didn't have a lot of information in the government. Or to be more precise, it really varied area to area. A lot of it I would attribute, and this is just my own view, to some of the different regulatory models. And when you had institutions that were regulated by the SEC, sorry, Alan.
I completely agree with you.
But by the SEC, by OFEO, the Office of Federal Housing Enterprise Oversight, which regulated the Fannie Mae and Freddie Mac, by the Office of Thrift Supervision, one of the banking regulators that is actually part of the Treasury Department, we found that they had very little information about the institutions that they were regulating. And so for the Bear Stearns collapse, the government had all of about 3 days notice, I think, of the run on Bear Stearns before we had to get involved. Probably about 5 days notice of the problems at AIG. And while everybody knew that Lehman by that time was very weak, in terms of when the actual run on the bank began at Lehman Brothers, again, probably no more than 2 or 3 days notice.
I think you overstate AIG too.
Well, that may be. That may be. It was. I mean, there's some comical discussions to talk to the main regulators to see if they even knew AIG was in trouble, and they clearly did not. So if you sort of roll forward to Dodd-Frank, what I thought is interesting is to take a look at Dodd-Frank and all of the other regulatory reform that's taken place. But most of it clearly centered in Dodd-Frank, to say, well, what was the impact on the tools? What was the impact on the information? I think there's some success stories and then some, to my mind at least, disappointments. To start with the success stories, actually, I think in terms of helping the government to have better information, I think that it will prove to have clearly made a lot of very positive steps in the right direction. I'm sure it will need to be fine-tuned. But the Act creates the Office of Financial Research within Treasury, which will collect and have much more information about financial institutions. It creates a much more robust, a very robust clearing system, which will result in the government having a lot of information about derivatives and derivatives trading. And that lack of information led to a lot of fear around the AIG unwinding. The Office of Thrift Supervision is being folded in a few months into the Office of the Comptroller of the Currency, and that I think will lead to a more robust informational gathering regime. And then you have the Financial Stability Oversight Council, which will be specifically gathering information and considering stability issues. You have other mechanisms like living wills and the Orderly Liquidation Authority by the FDIC, and Heath is going to talk about some of these in detail. But that will result, along with the fact that just the banking regulators have gotten much more aggressive at collecting information from the institutions and have become very sophisticated at analyzing it. A lot more information available to the government. Will it be enough that we will see the next crisis coming? I don't know, but certainly they will be better prepared than we were for the last one. To my mind, the big question mark there is the SEC, where I don't think anything has changed in terms of its style of regulation, which tends to be a very enforcement-oriented as opposed to supervisory approach. And it does lead to the question of what insight will we have into investment banking activity and the status of these banks.
If David will let me take 2 minutes of my 10 here. First of all, on that one, I don't think there is anything within the SEC that leads me to believe that it's changed what was, I think, a pretty subpar performance during the crisis. I think maybe the biggest thing that's changed is that because Morgan Stanley and Goldman Sachs are now both bank holding companies, the regulatory, the supervisory regulatory responsibility for the systemically significant investment banks is no longer resides in the SEC. And while it would be too bad for XYZ investment bank, small bank, to go under, it's not going to have the systemic impact of the things that have now been removed from its jurisdiction. I just wanted to add something to what Bob said about the information gap. I think that the tools gap is, I think, well recognized. The only point I would make is when Bob was talking about the FDIC, it occurred to me it's worth pointing out what all of you know, but I'll point it out anyway. Lehman was not a bank. And if Lehman had been a bank, the FDIC might have been able to do something to prevent what otherwise happened. I jokingly said it was Bob's fault. Bob could have easily said it was my fault. There was a 3-week stretch when I thought I was Typhoid Mary in August, September 2008, when I spent the weekend at the Federal Reserve Bank of New York, not down with the bankers trying to figure out how to save Lehman, but we were counsel to the Federal Reserve Bank in the bankruptcy of Lehman Brothers, and so we had the particular thrill of throwing the first spade of dirt on the coffin. The Fed didn't have the tools to save Lehman. If Lehman had been a bank, the FDIC might have had the tools to save Lehman. But the information point is, I think, even more telling in terms of what could the government do differently next time. The SEC, I wasn't there, and but I don't lightly criticize my old agency. Division directors don't criticize, former division directors don't criticize the FDIC. That's one of the unwritten rules. But there might have been more to learn after Bear Stearns disappears in 72 hours. There might have been more to learn about what the assets of Lehman really looked like and what the holes really were and what the toxicity really was between April of 07 and September of 08. It was not 3 weeks, it was a year and a half. And I honestly believe the SEC didn't know a whole heck of a lot more about what was inside, under the covers at Lehman Brothers than it would knew what was under the covers at Bear Stearns. You guys were in the government, and I don't know if you have a different view of that, but that was certainly the outsider's view. The second was Fannie and Freddie, and I said I was Typhoid Mary. 3 weeks before we put Lehman to rest, we were acting as counsel to Morgan Stanley, who was in turn acting as counsel to the Treasury in the euthanasia of Fannie and Freddie. One of the things that struck me at the time and still strikes me is, and this has now been said publicly, so I'm not telling tales out of school. The FDIC basically at the last minute had to send battalions of examiners into those agencies, again, to find out how big the hole was, to find out how big the capital gap really was. FIFA having announced in July that the capital was adequate. And again, the information gap was pretty serious. And without the information that was finally developed in a kind of emergency basis, Labor Day weekend or the weekend before in 08, the action that was taken vis-a-vis Fannie and Freddie, which was absolutely necessary, certainly in my view, couldn't have been taken, and yet the government didn't have it 48 hours before that. And so there's been a lot of talk about tools. There's, I think, been a lot less talk in the public debate about information, but in my view, that was at least as big a problem in terms of what you guys were facing as the tools gap, which was a real one.
No, I think that's right, and I mean, on the informational point about Fannie and Freddie, the Treasury needed to hire Morgan Stanley over the summer to figure out what was wrong. You knew something was wrong because the stock had gone down below $2. So the question was, what does Wall Street know that we don't know? And what Wall Street knew was that regulatory capital is some formula in the Federal Register, and economic capital is money you can use to cover losses, and that's what Morgan Stanley, as well as these examiners, figured out.
Right. It is. 30 more seconds. It's worth noting Fannie and Freddie. Fannie and Freddie is a little hobby of mine, because in 2002, when I was division director, Fannie, we negotiated. The Congress wanted to make Fannie and Freddie register, and so we negotiated a deal privately with Fannie and Freddie that they would become 34 Act registrants and have GAAP financial statements, which would begin to show economic capital. Albeit GAAP, which is not perfect, audited financial statements. The only thing I want to point out is Fannie, in fact, registered in early '03, then suffered an enforcement action in either '04 or '05 that I was there for because their derivatives accounting did not correspond with GAAP. Freddie, as it was marching towards registration, and this is also public, in early '03, announced it had a series of accounting problems it had to solve before it could become a registrant. They finally became a registrant in July of '08, on the way to the graveyard. And I think Wall Street, in fact, did understand what was going on. I mean, that gap was a joke on Wall Street.
Yeah, no, I think that's absolutely right. So on the disappointment side, it's sort of interesting as I look at the principal tools that were used to deal with the true crisis, and then to see how were these tools addressed in financial reform. So the Exchange Stabilization Fund was used to rescue the money markets. Congress, in the TARP legislation, inserted a provision specifically requiring that we would never do that again. So now, the way it got negotiated, it was narrow enough so that we could say, okay, we'll never use the Exchange Stabilization Fund to rescue money markets again by way of an insurance. But it was an odd reaction, I think, to one of the few tools we had that was used very effectively. If you look at Section 13.3 of the Federal Reserve, that was amended in Dodd-Frank, so it can no longer be used in aid of a specific institution. It can be used to lend to programs, but they essentially said you can't do Bear Stearns again. You can't do AIG again. You can't do Lehman, even if you could have done Lehman. Another, I think, sort of curious reaction to what was the single most powerful tool. The discount window, which was used to help a broad array of institutions, was weakened somewhat by both by litigation under the Freedom of Information Act requiring the information of who borrows from it to be disclosed, but then also by legislation requiring that those borrowings be disclosed. The systemic risk exception was basically obliterated in the form that it was used, and so it can no longer be used unless the bank goes into receivership. So if you have a situation, again, where you truly need to save the system, you can only do it by putting the system into bankruptcy, which would be a strange way to save the banking system. And the TARP legislation, which has certainly been controversial over the years, but at least if you look at the equity injections, succeeded and turns out to have turned a profit for the government already, even though not all of it is paid back yet. Enough has been paid back that the government has made money. You know, that certainly was a one-time authority, and I think Congress has sworn that it will never do that again. So on the tool side, somewhat disappointed to see the tools that worked were now taken away. So the next time the next Secretary of the Treasury comes to ask one of my successors, what are your tools? It's going to be an even lighter memo than I was able to produce for him. So with that, let me turn it over to Heath.
Well, terrific. Well, so we've talked a little bit, well, a lot about the crisis and the various powers of the government. I'm going to try to speak as briefly as possible because I'd like to probably, number one, hand it over to Alan, but also have some time for questions. But Dodd-Frank, for those of you, I'm looking out there and I see a lot of people that I know this is not your field, criminal lawyers, people in the government and whatnot. So taking a step back, Dodd-Frank is actually 2,300 pages full of legislation. Covers everything under the sun, from government tools to consumer financial protection, corporate governance, securitization, derivatives. It's literally the most fundamental change in financial legislation since the Great Depression, all sort of packed into one. The interesting thing about Dodd-Frank is that you would think with 2,300 pages, you would be able to take a look at a provision and say, ah, well, this is the way it's going to be. But in fact, Dodd-Frank delegates far more than it even says in the document itself. So if you've got 2,300 pages and you've got over 350 rulemakings, and even more than that are actually up to the agencies, discretionary. So Dodd-Frank itself, over the next 5 to 10 years, will actually comprise probably 30,000 pages of law. And so to give a seminar like this, or even a panel, we could have a year-long course on Dodd-Frank alone, and most of Dodd-Frank, we don't actually know what it is, because again, there's delegation. As of May 1,
You could write a book about it.
yes. And on that note, actually, and the remarkable thing, in all seriousness, I was in the White House as part of the crisis, working with Bob, and then went to the Hill to see sausage making / democracy and work. And I will tell you that, having read a number of books on the subject, your book, Professor Skeel, is by far the best, and it's only 196 pages. But really, if you're looking for an introduction to Dodd-Frank to understand the why and the big picture, definitely recommend your book, and we're using it for our associates at the law firm. As of May 1, there were 97 proposed rules that are out there. Only 21 have been finalized. 30 are out there but have missed the deadline. And there are 250 rules, regulations still out there. So a lot of Dodd-Frank is still very much up in the air. Again, I said Dodd-Frank covers sort of everything under the sun. Just real quickly, 3 areas I think are worth noting. Securitization. A large part of the financial crisis, or a major culprit, were risky mortgages and the securities derived from them. The so-called originate to distribute model. And I think you all sort of probably know what that is, even if you haven't heard that term before. Bank would go ahead, make a loan, immediately turn around and sell the loan off its balance sheet. That loan would be taken, pulled into a bunch of other loans, mortgage-backed securities would be issued, those then would be taken, turned into CLOs and whatnot down through the process. The problem was, of course, is that the original person making the loan officer, did not necessarily have the incentive to do the kind of due diligence that you would have maybe 25, 30 years ago when that bank was keeping that loan on the balance sheet. If you were able to take that, make a loan, and sell it the very next day, why on earth would you go through all the documentation? So in securitization, there are a ton of regulations and new statutory provisions, but big picture is the idea of the skin in the game. Now, for certain mortgages, if the bank wants to go ahead off and sell it, they basically have to keep 5% of the interest in that on their balance sheet. There are exceptions to the rule, and the proposed rules that have just come out have basically come out with a very narrow exception. So it looks like unless you want to do something that's cookie cutter, 20% down, you're going to have to be subject to this so-called skin in the game requirement. Another major market segment that Dodd-Frank seeks to radically change over the next few years are OTC derivatives, the so-called over-the-counter swaps market. Perhaps the most sort of notorious or well-known of these were credit default swaps. Situation is basically two parties enter into a transaction where they bet on the default or bankruptcy of a reference entity, a third company. So just as an example, Raj, who's sitting there, class of 2005, welcome Raj, enters into a credit default swap with me, name a company.
IBM.
To IBM. So he's betting that IBM will fail. I'm betting that it won't fail, and we're swapping an interest rate essentially. The way this works though is if IBM's rating goes up or down, rather than us closing out our contracts, he will just turn around and do an offsetting position with, let's say, Diane. She will then do the same thing, and what you have is a series of bilateral contracts that are privately negotiated, so-called daisy chain. And what happens is if there's a financial shock, and let's say I go insolvent, Raj looks to me, Diane looks to Raj, what happens? What happens? So that's sort of the big picture here. What Dodd-Frank seeks to do is to create a centralized clearing system where all of those over-the-counter swaps are sent through a clearinghouse, and the clearinghouse then steps in between the parties and is the counterparty to every transaction. So everything now will be fed through a clearinghouse, and the underlying theory is the government will watch the clearinghouse. Now, if you think about that, risk is not so much reduced, but it's concentrated. So the question is, well, what happens if a clearinghouse goes down? Now you've created an entity by definition is too big to fail. So in some sense, it's an example of where Dodd-Frank seeks to solve one problem, but arguably creates another. Another area, the Volcker Rule. A lot of you have heard of that. The Volcker Rule is not a return to Glass-Steagall. It's not investment banking and commercial banking can still go on. The Volcker Rule targets two things: proprietary trading and hedge funds and private equity activities. Interesting thing about the Volcker Rule is, unlike the derivatives markets and unlike asset securitization, I have found no empirical evidence, and indeed I think Mr. Volcker himself has agreed or conceded that these areas had nothing to do with the financial crisis. But they are arguably dangerous exotic activities and could be the cause of a future crisis. But I understand Alan has worked on this issue, so why don't I turn it over to you going forward.
All right. 1 minute on Volcker. I think you're absolutely right. The group of 30 report that Paul first championed this rule on, we were actually, or a couple of us were counsel to that group, and his theory, I think, is it's activity that could be dangerous and should be stamped out, even though there's no empirical evidence that it caused a crisis. He would argue that it was a major contributor to the need for leverage, which made the system more fragile than it otherwise would have been. And that's the closest you can come to an empirical statement that's demonstrable, I think. On the rest of Dodd-Frank, what I'm going to spend a very few minutes on, I hope, because I do think we want some questions, is there's a whole bunch of Dodd-Frank, maybe in terms of the 2,300 pages, nowhere near most of it, 200 or 300 pages of it probably, which doesn't relate to financial institutions, which relates to corporate governance and particularly executive compensation related provisions that apply to public companies generally. And one fair question is, why are those provisions in Dodd-Frank? And the best explanation from my point of view is because their proponents could get them in there. I think this really was part of the sausage making process and not part of the principled process. A lot of the ideas that are now enshrined in Dodd-Frank have been around for years. When we did the executive compensation disclosure rules in 2005, the House Financial Service Committee was asking us why there wasn't a say-on-pay vote, and we said because we don't have authority to demand it. And well, in 2010 they finally provided that authority. But things like that had been around for many years. They've been lurking around in bills that have been introduced in the Hill in various forms for up to the last 10 years. The issues worth talking about very quickly, a lot of executive compensation issues. Say-on-pay is one of the 3 of the 21 rules that Heath mentioned that are currently in effect are the say-on-pay and the related say-on-frequency. Will there be a vote every 1, 2, or 3 years on pay at each particular company? And what I affectionately call say-on-shoots, which is a non-binding vote on golden parachutes as a result of acquisition transactions that haven't previously been approved by the shareholders voting on the transaction. Say-on-pay, clearly the most important of the 3. TARP put it into effect for TARP recipients last year. It's in effect for everybody this year. A small but still larger number, I think, that most people expected. 16 companies have had more than 50% votes against their top 5 executive pay packages. The most interesting question there, frankly, is going to be what are the comp committees at those 16 companies going to do going forward? Are they just going to ignore it? There's some memos out there that suggest they have every right to ignore it. That's true. They have no fiduciary duty to do anything. I don't think it's a very good governance or political reaction not to do something in reaction to a negative vote. I think those companies that really demonstrably do nothing will find themselves facing vote no campaigns on directors in the following year. There also, one of the unintended consequences of that vote already, there have been 2 derivative actions at least, maybe there's a third now, filed against the directors of the companies that have suffered those negative votes, that the directors have breached their fiduciary duties. There's been a lot of press about those recently. My own personal view is that the chances of those succeeding is pretty slim, but they're out there and they're another cost of doing business that probably nobody needs. Bounty provisions, not executive comp related, but perhaps the most dangerous provision in Dodd-Frank on the governance side, provides for if a whistleblower goes to the SEC and the CFTC and there's a sizable recovery as a result of that tip, the SEC and the CFTC can give the whistleblower between 10 and 30% of the recovery. That kind of money threatens to undercut what most companies have been trying to do for the last 10 years, which is strengthen their own internal whistleblower programs, trying to make them anonymous, trying to convince their employees that there really is no retaliation, trying to have an effective response to whistleblowing. There's a lot of skepticism out there that those programs really are effective. I think employees share that skepticism. And when an employee looks at that on the one hand and a potential 10 to 30% recovery and 7 or 8 figures on the other hand, there is a lot of concern among audit committees and boards and managements that tips will go in the first instance to the regulators. The proposed rules, this is one where the rules are proposed but not yet effective, provide that you still get the bounty if you go to the company first, but don't do what the companies would like, which is to say you only get the bounty if you go to the company first. There's been a big lobbying campaign to get that into the final rules. I think the chances of getting that without legislation are very, very small, in part because I don't think the legislation reads that way as currently drafted. The final point on that is I think it sets the agencies up to fail again, because they're going to find, they're going to miss one of those great tips which comes across the transom, because a fair number will come across the transom. And when they miss the big one, just think Madoff. and think about why you would expose yourself to that again, and then explain to me why any agency would want this provision. But there it is. Couple of other exec comp things: independent comp committees, rule proposal, less meaningful than it sounds, because the listing standards that come out of it will really, I think, just mandate that the exchanges and the companies think about various factors of independence rather than mandate the kind of strict independence that audit committees operate under Sarbanes-Oxley. That's not necessarily a bad thing. Think about a company that's got a 10 or 15% VC, venture capital or private equity holder. There's a good argument you don't want those people on audit committees. There's also a good argument that you do want those people on comp committees. They've got skin in the game. They really will stand up to the CEO. They really may result in arm's length bargaining of the sort that doesn't largely exist today. So that's really not a bad thing at the end of the day. Clawbacks. There's a provision in Dodd-Frank that will require, as a listing standard, that companies claw back from their executive officers any incentive comp that results from erroneous financial information reported to the SEC. It doesn't matter whether the executive in question did anything wrong. Indeed, it doesn't matter whether anybody did anything wrong. A mistake in your GAAP financials will result in clawbacks under this rule. most companies have moved partway in this direction anyway, although on their own, most companies are requiring fault. I think there are a couple of unintended consequences here that are possible. One is more discretionary bonuses. One is more bonuses that are tied to metrics that aren't tied to financial statements or financial information required to be reported to the SEC. Think same-store sales. Think productivity measures. Those will not be part of those will not be subject to the statutory clawback provision. 10 more seconds. There are some disclosure proposals in Dodd-Frank: conflict minerals, extractive industries, mine safety, pay for performance, and pay parity ratios, all of which will go into effect over the next couple of years, some of which will probably have more pernicious effects than others. But that's kind of the package. I haven't touched on the Consumer Finance Protection Board. We'll leave that for next year.
Or for questions. Very nice. So we have about 5 minutes for questions. So Diane has one right away.
As someone who specializes in white-collar criminal defense, I'm very surprised at how few criminal prosecutions there have been of individuals that really were responsible for the financial crisis, whether it's individuals in the ratings agencies that rated these CDOs that were full of subprime mortgages, AAA, or people within AIG responsible for these credit default swaps. As people in the government who kind of had to make heads or tails of this mess, I'm curious what your thoughts are on the very lack of criminal prosecution.
I mean, I think there were people that did indeed commit fraud and act with malice intent, but I think a lot of the people out there, some of them didn't know what they were doing and didn't understand the risks they were facing, and those aren't crimes. So I think that the Madoff crowd and those kind of egregious violations, my guess is there will likely be more prosecution of them in the years to come, but a lot of people were just sort of, the system itself was bad, the originate to distribute model, the derivatives, and just calculating of risk, the measures of risk were not necessarily, didn't evolve with the actual complexity of the instruments. So I'm not sure how much crime was actually involved as much as, misunderstandings.
I think, incompetence is not a crime.
I was trying to put it a little bit more politely, but yeah.
I think
the ratings agencies.
Sorry?
The people within the ratings agencies that
I don't think. You see, I don't. I think there are probably small fish out there against which it's easier to make criminal cases than large fish. But if you think about the political and prosecutorial resource decisions that faces you with, one, are you really going to spend $2-3 million prosecuting the third assistant vice president who really knew that mortgage was, or that transaction was fraudulent? Are you really going to go after the guy at the rating agency who rated the security and knew he wasn't rating it or she wasn't rating it properly when he's the second assistant vice president? And think about the political outcry, because you're not going after the big guys. So, and the problem with the big guys, you're the CEO, you're told by your chief risk officer, these things are safer than treasuries. You were wrong, he was wrong, but you're not going to prosecute anybody for that, in my view. Can you prosecute the institution for that? Yeah, but how many of the top 15 financial institutions in America do you want to sign deferred prosecution agreements with?
Well, we're almost out of time, so why don't we take several questions, kind of seriatim.
How many of these guys were just willfully blind?
But I'm not going to let them answer until we get the question. So ask your question, then I'll.
Yeah, how many of these guys were just willfully blind because there was so much money?
Okay, so that's
you
what.
call them incompetent when they're the best and the brightest. How can that be?
Just a second.
One question. Same question. Y'all are kind of positing that Wall Street is incompetent, and we really take a serious risk when we send our money up there.
Okay, another question?
The question is,
And then
generally, the theory is that the crash happened because of lack of regulatory action. Had the regulatory agencies used the tools they had, it might not have happened. My question, I guess, is one, is that a fair assessment? Could it have been avoided with better regulation? And two, even with Dodd-Frank, if you have a administration that doesn't want to regulate, does Dodd-Frank really mean anything in the long run?
And then this will be the last question. I'll let each of the panelists have 30 seconds or so to reply.
How much debate went on within the government with respect to whether or not there should have been a bailout TARP program at all, and cut it off and let the system solve its own problems as opposed to government intervention?
These are great questions. So let me, I'll just go from Heath across. So Heath will have 30 seconds, and then Bob, and then Ellen. To respond to whichever of the questions you want to respond to.
I'm sure there were instances of willful blindness. May not be uniform, but I'm sure in certain instances, people that were very close to certain instruments may very well have thought that, there were problems. Yes, there was definitely a lot of discussion about whether to do any TARP-like program, particularly as the TARP thing continued on and auto companies were involved and it went beyond financial institutions. Should we keep sending our money up there? I really don't know. I think a lot of people, again, bubbles happen, and that goes to your question, is that this may have been far more complex. There were years of low interest rates, which created a bubble. So yes, less regulation can certainly contribute to the crisis, but sometimes crises occur and you can have all the laws on the books and markets work and governments don't.
I guess I would say one of the most disappointing things in the aftermath of the crisis is how little progress has been made in seriously studying the cause. Was it crooks? Was it incompetence? Was it bad government regulation? Was it all of the above? Certainly there were elements of all of the above. But how did it really work? Congress created this Financial Crisis Inquiry Commission, which I don't think many people think advanced the ball very much in terms of our understanding of what happened and how we might avoid it in the future. And that's a real disappointment. On the question of, was there consideration of just, let it play out, let the market work? There was a lot of talk about that. I will say for my part and the people that I was around, there was a genuine belief, which I continue to hold to this day, that had we just sort of let these companies fail and let the market, work its, Adam Smith magic and so on, that, the financial crisis for the country and the world would have been catastrophic. I think some studies were done sort of, would have showed, for example, an unemployment rate in the U.S. north of 25%. If you think 10% felt bad last year and that 9 or 8% feels bad this year, think about what 25% would be. So I'm certainly glad as a, Republican sort of free market kind of guy, I have no qualms about the government having intervened.
Alex?
Yeah, I'll start with that. I don't know what you do about willful blindness if you're a prosecutor. I know what you do about it when you're a regulator.
It's not a crime, but was anybody embarrassed? I mean, is there any shame?
I know what you do about it as a regulator. I don't know what you do about it as a prosecutor.
But, I mean, is there any shame in
there's some shame to go around, not maybe in the places you'd like it. I think the most interesting point is Bob's. I think having sat in those, I didn't sit in the government, but I sat in enough of those rooms in October and September and October. I think the story of TARP 50 years from now will be that it saved the economy from a whole heck of a lot worse than it would have faced without it. I think the bailouts are discomfiting. I think I understand the reaction to the bailouts in Dodd-Frank, which is largely to take away the tools that would have permitted them to happen again. Congress, of course, if it gets bad enough, can reverse field. You couldn't have done TARP without Congress, and a different Congress might produce a different result.
You barely did it with
I remember that too, barely did it with Congress. whether Dodd-Frank will solve, will be an adequate solution to the next problem, I honestly don't think, I think any answer to that question is, until it happens, is purely speculative. I think you absolutely can't tell. I hope my professional career is over before that question has to get answered. The frequency with which these crises seem to be rolling along right now, you know, my wish may not be fulfilled. But I do believe your point about is a very good one, and I'll close with this in respect of it's the it's the character of the administration and the people within the administration, and how they're going to react to the availability of particular tools and particular information that matters as much as the memo that Bob wrote about what's in the toolkit.
That's a nice note on which to end, and please join me in thanking